Mr. Barr, can you hear me?
Yes, Judge.
Okay. And good morning, Judges Sasso and Harris.
Good morning.
We'll wait until 9 o'clock sharp. Yeah, it's 9 o'clock sharp. All right. All right. Good morning and welcome to an oral argument session of the 5th District Court of Appeal. My name is Rand Wallace. I'll be presiding over these cases this morning. I have joining me on this panel, Judge Meredith Sasso from Orange County and Judge John Harris from Brevard County. Just ask the parties to please keep your microphones on mute when you're not speaking, and also make sure you have any noise-making devices silenced in the background so that doesn't interrupt the parties in their presentation of the cases. We have two cases set on the docket at 9 and at 10 o'clock, but the facts are very similar in those cases. I just want to make sure the parties would agree with my assessment of that. Mr. Middlemark, is there any record you'd like to make with regard to that?
I believe both cases are similar factually, and whatever distinctions factually they have are not significant, and I believe we can cover both with the same oral argument.
Okay, and Mr. Barr, would you agree?
I would agree with that, Judge.
Okay, procedurally, you all have 80 minutes, so but you're welcome to use all 80 of those minutes if you want. But I would propose that we could just start with the cases, and however you all want to divide and or argue your time with those two cases. I think we're very well of the facts in the case. But I want to give you all, every minute that you want to argue both cases, because it's a lot of work that you all put into the cases and that we've put into reviewing the cases. So please don't take my statements as you need to shortcut anything that you're doing. But I will just leave it up to you all as far as how to address and handle the cases, any way that you all propose. But Mr. Barr, you're the appellant in both cases. So I will let you go ahead and argue, and then whatever time you want to reserve for rebuttal, just let me know and we can put that on the clock. But you've got 80 minutes, or 40 minutes apiece.
I've done this before, Judge, and I think that what we tend to agree to is just both sides having their 20 minutes so as to just keep the issues concise. I mean, that would work. That would work for me if Mr. Middlemark's in agreement with that.
I agree.
Okay, sounds great. So, Mr. Barr, you have the floor.
Thank you, Judge. I'd like to reserve 5 minutes for my rebuttal time. May it please the court, my name is Chad Barr, and I have the privilege of representing the appellants in these two cases this morning. We're here asking this court to reverse the trial court's order of dismissal with prejudice in both of these cases. The primary issue that this court has to decide in these cases is whether the trial court erred in dismissing the appellant's complaint for PIP benefits based solely on a generic default judgment that was attached for the first time to the appellee's motion to dismiss, which required the trial court to venture beyond the four corners of the complaint, and that was entered in a declaratory judgment action that the appellant was not made a party to. In our brief, we've laid out both the procedural and the substantive errors that we believe the trial court's order presents, and those are the issues that I will be addressing during oral argument today. Any of the reasons that we've set forth in the complaint, there's roughly 7 issues that we've raised in the initial brief. Roughly any of those standing alone are sufficient for this court to reverse the order of dismissal, but I will spend some time going through them. I think it's worth noting from the outset that Direct General's practice of running around the state of Florida and suing its insureds who have assigned their insurance benefits and then walking away with default judgments and using them against medical providers is becoming a problem of epidemic proportions in the state. To understand the sheer number of these cases, we only need to look at the answer brief. Literally every single case that Direct General cites to in support of its arguments is a county court case where Direct General or one of its subsidiaries, which is usually Imperial Insurance Company, has sued one of its insureds in a declaratory judgment action, has obtained a final default judgment against the insured, and then used that default judgment against the assignees to avoid paying PIP benefits. We now have this issue pending in every district court of appeal in the state of Florida. And this, just highlighting the importance of this case, this is the first set of cases to be set for oral argument on this issue. So what I'd like to do is start by just addressing the procedural issues that we believe are raised by the trial court's order of dismissal. First, consideration of the final judgment, the default judgment, required the trial court to go beyond the four corners of the complaint. So when deciding an issue of a motion to dismiss, there are three bedrock.
Could I stop you there for a minute? And I think I just have I guess, a blanket procedural question. It being a motion to dismiss, at any time in the hearing, did the trial judge express concern or cite to any way that the complaints were deficient in their pleading the facts and the ultimate facts for a cause of action?
I don't recall that specifically, but what I can say in response to that is what we've got is a complaint that's pled that the insured was, or the patient, the assignor was insured pursuant to an insurance policy, was injured in a motor vehicle accident, that the appellant provided treatment that was reasonable, related, and necessary, and that Direct General refused to issue payment. So those are the four elements of a breach of contract action. So I don't recall specifically if the court raised an issue with regard to the sufficiency of the pleadings, and it certainly wasn't addressed in the order of dismissal. And I think that we can look at the record and see that we've set forth a claim for breach of contract. I don't know if that answers your question or if there was a secondary part to that.
No, I mean, I think my concern, obviously, with the motion to dismiss is you're focusing on the four corners of the complaint. And so my question was there any allegation and or argument made by the appellee in the trial court that would express any concern as to how the complaint was deficient in pleading a cause of action?
The only argument, based on the record, the only argument made by the appellee was that the complaint cannot survive the default final judgment that was entered in the separate declaratory judgment action. So there was no allegation that the complaint didn't allege the elements of a breach of contract action.
Okay, thank you.
And so the bedrock principles that the court has to adhere to, the trial court has to adhere to, is that it's confined to the four corners of the complaint, must draw all reasonable inferences in favor of the pleader, and it must accept all well-pled allegations as true. So as I just discussed, we set forth the elements of a cause of action for breach of contract in our complaint. So essentially, the inquiry should have ended there. A motion to dismiss is designed to merely test whether the allegations, when taken as true, demonstrate that the pleader is entitled to the relief demanded. It's simply a test to ensure that the elements of the cause of action have been pled. And as I just indicated, there was no argument that the elements hadn't been pled in this case. A motion to dismiss is not designed and should not be treated as a summary judgment proceeding. In this case, instead of taking the complaint to well-pled allegations, setting forth a breach of contract action, instead of drawing all reasonable inferences in favor of the appellant, instead of confining its view to the four corners of the complaint, the trial court considered what I refer to as a generic default judgment from another case that was attached to the appellant's motion to dismiss. It's important to understand that I call it a generic default judgment because it doesn't state who the named insured is. It did not state what the policy number was. It did not state what the policy period was. It did not identify this accident. It did not identify this claim number. It did not identify any insureds, and it did not identify any assignees. What I find interesting is that when you read the answer brief and it cites to the portion of the trial court's order of dismissal, when it refers to the default judgment where it states named insureds, the appellee actually uses a bracket and inserts the name of who it says the named insured is. When the default judgment says omnibus insured, Direct General uses brackets and inserts who this court should understand the omnibus insured to be, which is either the named insured or the other insured in this case. So I call it generic because that's exactly what it is. We get no information from the final default judgment that Direct General attached to its motion to dismiss. What I find interesting as well is the answer brief concedes that the trial court knew, it says the trial court knew from the default final judgment that the policy was void ab initio, but it provides no legal support. The answer brief provides no legal support whatsoever for the trial court's ability to consider the default final judgment in relation to a motion to dismiss. We cited several cases from this court demonstrating that the trial court erred when it went beyond the four corners of the complaint, and the answer brief cites to no cases. The only cases, again, it cites to are county court cases where it was a party in a virtually identical type of case. The answer brief counters by arguing that the trial court properly considered the generic default judgment pursuant to section 90.202, the Florida Evidence Code. But that argument's been rejected by every district court of appeal. We've listed those cases in our initial brief. Every district court of appeal has held that Florida statute section 90.202 cannot be used to allow the trial court to consider documents outside of the four corners of the complaint. There is a very limited exception, but it's not applicable in this case, and it wasn't argued by the appellee in its briefs. Again, in every single one of those cases, the court's rationale is that these cases, that a motion to dismiss should not be treated as a summary judgment motion, but instead should be treated as merely testing the sufficiency of the pleadings, not whether the facts alleged are actually provable. And so
it's my understanding that there's no procedural quirks between these two cases, and that the response to the motion to dismiss in both these cases raised this argument that you're making now. It was presented again at the hearing in both of these cases, and you've of course presented this as a basis for reversal in your brief. Is that your understanding as well?
Yes, Judge. And the court didn't reference it in its order, but the arguments were below and the arguments were raised in the briefs. The second procedural issue is the trial court improperly resolved disputed issues of fact. The law in Florida is abundantly clear. A trial court cannot resolve disputed issues of fact at the motion to dismiss stage. A court can't consider affirmative defenses, and if it can't consider affirmative defenses, then it shouldn't also consider avoidances to affirmative defenses. Affirmative defenses in this case would be that there is no coverage and that there is no policy. The court considered these issues at the motion to dismiss stage. And I want to just be clear that we're not arguing, we've never argued that Direct General can't rescind an insurance policy in the context of a PIP claim. But we're saying that even if it's appropriate for the court to consider the default judgment does not on its face resolve the coverage issues in this case because there's no specifics to the default final judgment. And then the last procedural issue is that the court considered the default final judgment without certified copy of the court file or the relevant filings in that case. What I think is important for the court to understand is that the default judgment refers to the complaint filed in that case, and the complaint was never proffered by the appellee in this case. It was never considered. There were no certified copies of the documents, and the defendant did not present, or the appellee did not present the entire court file from that case. But even if the court disagrees with me on the procedural issues, there are very important substantive issues that also require reversal. And I think most importantly, and the easiest one to address first, is that section 86.091 states that a declaratory judgment action does not prejudice the rights of non-parties. The literal effect of the trial court's ruling is that the appellant, despite having an assignment of benefits that was executed in its favor before the default judgment was entered, does not have any rights in this case. This directly conflicts with the plain language of section 86.091, which again states no declaration shall prejudice the rights of anyone who has not made a party to the declaratory judgment action. The statute 86.091 does not provide any exceptions to what it says. There are no exceptions. So while a party who brings a declaratory judgment action doesn't have to include all the parties, there is certainly a risk in doing so. And that's the risk that Direct General undertook in this case. This issue was directly addressed by the 3rd District. I would argue for the first time in the Allstate versus Warren case. And according to the Warren Court, a declaratory judgment is only res judicata of the matters between the parties and their privy. Direct General has never argued that the medical provider is a privy with the insured in this case. So there's no basis for the declaratory judgment, default judgment, to also bind the medical provider in this case. And there's also the Palakas case, which I also believe directly addresses this issue. The only avoidance that Direct General gives to these cases, the only way it tries to distinguish them, is simply by saying, well, those cases didn't involve the rescission of an insurance policy. I would argue that it doesn't matter. And if it did matter, certainly there would be a case out there that said so. And there's not a single case in the answer brief that supports that position. The argument that it is binding, the default final judgment is binding, was also rejected by the 3rd District in the Burrito versus Heritage Property and Casualty Insurance case, which is also cited in the initial and reply brief. And in Burrito, the court refused to apply the doctrine of res judicata and collateral estoppel, explaining that there is no mutuality of parties when there is an assignment of benefits involved. The assignee and the assignor are not one and the same. They are different. And we were looking forward to Direct General trying to distinguish an assignee and an assignor in its answer brief, and it absolutely did not do so. The Middle District's decision in Helt versus Liberty Mutual ties it all together. In that case, a court declaratory judgment action was filed by Liberty Mutual, and in fact, Liberty Mutual obtained a final declaratory judgment declaring that the policy was void ab initio. Relying on Warren, the Middle District refused to dismiss a subsequent lawsuit where Liberty Mutual argued that the prior declaration that the policy was rescinded controlled the issue in that case because the party was not a party to the declaratory judgment action. The next substantive issue is that Florida law holds that a default judgment is only binding against the defaulted party. I don't believe I need to do a whole lot of explaining on that. It's pretty self-evident. The appellee has not provided a single case that states otherwise or that avoids that particular legal principle. And lastly, the order of dismissal violates the appellant's fundamental due process rights. In this case, the appellant solely owns the cause of action. It has the right to enforce payment, and it has the right to litigate coverage issues. This court has clearly held that on numerous occasions. And when the trial court dismissed the cause of action based on a default judgment and a declaratory judgment that my client was not a party to, my client was denied its day in court without notice and an opportunity to be heard. So for these procedural and substantive reasons, we would ask that this court reverse the trial court's order of dismissal in these 2 cases, and I'll reserve the remainder of my time for rebuttal.
Thank you, Mr. Barr. Mr. Middlemark, you may proceed.
Thank you, Judge Wallace. So Mr. Barr and I can agree on a lot of things in this case. The facts are immutable. And what we know is there was an automobile accident and Estelle Jean Baptiste executed an assignment to the healthcare provider KC Quality for treatment that was rendered on July 30th. That's the same exact scenario regarding the Macine Hercule case. So the day of treatment, July 30th, and that's the day the assignment was executed. So in the Jean Baptiste case, which I'll focus on primarily, Direct General filed a declaratory judgment action on October 19th, 2020, which was before the complaint for PIP benefits was filed by KC Quality. So KC Quality files their their complaint, and then Direct General files their motion to dismiss. I'm not going to get into without somehow the allegation that Direct General has done something insidious because of going to obtain a declaratory judgment action against their insured.
Mr. Middlemark, was the motion to dismiss that was filed in the trial court, did that attack the sufficiency of the pleadings with regard to the complaint?
No, Your Honor. No, Judge Wallace, it did not. And if you'll take a look at the hearing transcript, there's no question in this case that the complaint was sufficiently pled to assert a claim for PIP benefits against Direct General.
You do acknowledge that it was originally well pled.
Correct.
Anything to support your allegation that because of the default, somehow it's no longer well pled? And how
Yes,
do you get to that if you can't look outside the complaint?
because of all these orders that we've obtained throughout the state of Florida.
Obviously, we're, not bound by county court orders. So as an original matter of first principles, why is it appropriate to look outside the four corners of the complaint in this case?
Because there's somehow a fiction that this complaint was well pled when it made conclusory allegations that the policy was in full force and effect. And
What's the fiction, Mr. Middlemark? You just acknowledged that it was in fact well pled when filed.
it was well pled when filed. I'm sorry, I didn't mean to interrupt you.
Why isn't the end of the issue? If it's well pled when it's filed and you can't look outside the four corners, doesn't it remain well pled? I mean, you're alleged in your brief that it somehow lost that status of being well pled because of something extrinsic. How does that happen?
Because in this particular case, it involves an assignment given by an insured to a medical provider as the assignee, and the assignee stands in the shoes of the insured. It's simple assignment law that we're applying that takes this case out of the general law that you can't look outside the four corners when we know that the policy has been declared void ab initio with a legitimate circuit court order. So
Is there, obviously there's a pleading requirement. The rules of pleading are set by the Florida Supreme Court. I think when you're talking about a fiction, you're saying we know all these facts in general, but as you know, we have pleading requirements and rules of procedure in Florida. And so is there any case in your view, appellate case or Florida Supreme Court case, that suggests that the court could have looked outside of the four corners of the case in this context of the complaint, rather?
I have searched throughout the state of Florida and I have no district court of appeal cases. All I
So
have.
you would agree it would be a novel position for this court to take, that's to say that in this circumstance, because we know there's issues outside of the complaint, that we should be able to look at them.
That's correct. That's what I'm asking this court to do, because
How? I mean, what rule would we write in our opinion that would achieve your position and not completely upset all of Florida law on pleading requirements?
because in this case, Direct General obtained a declaratory judgment that was entered by a court of competent, a circuit court order, which says that there is no coverage to the insured Estelle Jean Baptiste or any omnibus insured, which in this case is Maxine Hercule. And a court has inherent power, like they did in this case, to utilize judicial notice under 90.202 to recognize that a policy is void ab initio. So
how do you distinguish that case, that what you're saying, what this court would write, with Hugh Laboratories versus Murphy? It's a third DCA case where even on a judgment for pleadings, it says the trial court is not authorized to take judicial notice of records in a different case pending or disposed of in the same court, but outside of the record in the case before the court. Do you think that case was wrongly decided, or do you think, go ahead.
I'm sorry, Judge Sasso, I anticipated your question. And the answer is no, it's not wrongly decided. What I'm asking this court to do is apply well-established assignment law, because the Hughes Laboratory case didn't involve the same issues as this case, where you have a named insured assigning benefits to a healthcare provider and then having that policy declared void ab initio. We understand you can't go outside the four corners of the complaint. And what we're asking this court to do is take a leap and say assignment law. And I don't know if this court's willing to make that leap, but every circuit court that I cited, county court that I cited to, was able to make that leap, because you just can't make allegations in a complaint and say that they're well pled when we know that they're not well pled. And we have judicial notice of a legitimate court order saying that the policy is void ab initio. And there was no set of facts that appellant can argue that would undo the voiding of this policy ab initio. And
Why wouldn't that be more appropriate for a summary judgment? For instance, here, the motion to dismiss does not allege any affirmative defenses. It doesn't raise words like collateral estoppel or res judicata. We're not even sure why the county court, whether it was an indispensable party, whether it was a res judicata, whether it's collateral estoppel, all of that is completely unclear of the record because you've subverted this procedural process. So why would this court want to put ourselves in a situation where all of that is being ignored based on an expressly created exception for assignment law that the Florida Supreme Court has not placed in the rules on pleadings or on motions to dismiss?
again, I can only continue to argue the same arguments I made in my answer brief, and that is we know in this particular case, Judge Ashton had a complaint that was filed, which contained the insurance policy that's at issue, and alleged in that complaint that the insured made material misrepresentations, and that insured defaulted, and a judgment was entered stating that material misrepresentations were made by the insured. And so we know.
Does the judgment say that?
The judgment says the policy is void ab initio.
It doesn't say why though, right?
It does not, but the complaint, as part of the court file reviewed by Judge Ashton, spells out exactly Direct General's position. The insured.
Those are just allegations, though. Those are allegations. And so my concern, Mr. Middlemark, is you're asking us to quote unquote take a leap. Taking a leap to me is also another way of saying create your own case law or make assumptions about and go ahead and commit to general accusations. So just saying there were material misrepresentations and we have in neither of these files any indication based upon a finding by a court. I understand you have allegations, but there's no finding by the court as far as what these misrepresentations were. Is that correct?
Yes, in part. So what I'll say to you, what I'll respond to you is the complaint alleged the misrepresentations made by the insured and refer to an examination under oath that was given by the insured on August 10th, 2020. And so as we talked about in this particular case, the complaint was well pled. So was the complaint well pled in the declaratory judgment action filed by Direct General, because the court had an opportunity to review the complaint, review the clerk's default, have a hearing on the issue, and then enter the default final judgment, which makes all those allegations in that declaratory judgment well pled. And so there's no set of facts that appellant can allege in this case that's going to make this policy not void ab initio. And so it's not so much a leap, it's this court needs to affirm the county court orders that have consistently held that when you have a default final judgment, finding a policy declared void ab initio, you cannot assign a healthcare provider cannot pursue a claim for benefits under that same policy that's void. You just can't pursue a claim for breach of contract when the contract doesn't exist. So whether you want to carve out an exception, it's not as simple as that. It's simply to affirm the trial court, in this case, the county court order in this case, because it was based on well-pled principles of assignment law and also well-pled principles of material misrepresentation that was committed by the insured in this case, who happened to be the assignee and the named insured. And then in the other companion case, that insured took their rights under the same insurance policy. So again, it's what the trial court did in this case was absolutely correct, because we know you just cannot make an allegation in a complaint and have it stand when there's facts that are immutable, that cannot be changed, that the policy is void ab initio due to material misrepresentations. And so, again, excuse me, not, but the cases that were cited by appellant, they have no district court cases on point to justify their position with these same set of facts. Allstate Insurance Company versus Warren, Allstate was a garnishee because an injured party obtained a judgment against the insured. This is not the same situation. The insured here voided the policy with the policy was voided due to their material misrepresentation. The healthcare provider in this case is not an injured party. That's the distinction. The same thing in that independent fire versus Palekis case. There, the injured party got a consent judgment from the insured. This is not that case. This is an assignment case where the assignor gave the assignee an assignment that's a fiction. The Burrito case is really the case that I think needs the most discussion, because there, what you had is a property insurance policy, not a PIP, or excuse me, an automobile insurance policy. But there, the insured gave an assignment to a mold company, and the mold assessment company went to trial against the insurer. There was no question of coverage. There was no question of whether that policy was void ab initio, and that's why that case is distinguishable. And then, so the closest case we have that I'll concede is this Health versus Liberty Insurance Corporation case. And Liberty, in that case, did get a declaratory judgment finding that the policy was void. And so what you have then is an order to show cause why the insured, why the injured party can't go after the insured or the insurance company. And in that case, they obtained, they being the plaintiff, obtained an unsworn statement from the insured. So here, as I put in my brief, appellants knew about the declaratory judgment action and did nothing. And now they want to say that, oh, we didn't get due process, we weren't put on notice. And that is another fiction. So what we have here are a set of facts that, in this case, Judge Starr, and in the other case, Judge Carter, found were completely appropriate to find in Direct General's favor. The assignment law is well established in Florida, and when a policy is void ab initio, there are no benefits to assign. And that's why in this case, and in the companion case, Messine Hercule case, both trial courts got it right. And this case, this court should affirm the trial court and conclude that there is no set of facts that the appellant can rely upon to have their complaint be well pled. So based on those grounds, I request that this court affirm the trial court.
Thank you, Mr. Littlemark. And Mr. Barr, you have a little over 5 minutes.
Thank you. What I'll just say in rebuttal and ending into a conclusion is that Direct General's position is not supported by law. It's contrary to the law. And all we have to do is look at the talking points that were presented by Mr. Middlemark to see that, asking the court to take a leap, referring to each of the arguments that we raised in our initial brief and below as fictions, when there are ample case law cites in the briefs supporting our position and no cites in the answer brief disproving our position. All we have to do is look at the fact that we pled a claim for breach of contract. And if we have to litigate or resolve the issue of the rescission of the insurance policy, it needs to be done in the context of a motion for summary judgment. So what we have is we have all of the puzzle pieces. So the pieces of the puzzle are clearly defined in this case. A declaratory judgment is not binding against a non-party. A default is binding only against a defaulted party. The appellant is not in privity with the insured. And the appellant, as the undisputed holder of assignment of benefits with due process rights in this case, is the sole owner of the claim and has the right to enforce payment and litigate coverage disputes. It had an assignment before the default judgment was entered, and the court cannot go beyond the four corners of the complaint. When the puzzle is all put together, the picture we get is quite clear. The trial court erred as a matter of law in dismissing the complaint. If the appellee wanted to extinguish the rights of every claimant to benefits under the insurance policy it claims was cited in the complaint and the declaratory judgment action, then it should have and could have named those individuals as parties, but it intentionally omitted them. What we are seeing in this case is not the effect that the law regarding motions to dismiss was intended to achieve, and what we are seeing in this case is not what the declaratory judgment statute was intended to achieve. Because the trial court violated procedural and substantive law, we would ask the court reverse the trial court's final order of dismissal in both cases. Thank you.
All right. And obviously a little different procedurally because we have two cases. I just want to make sure, Mr. Barr, do you have any additional arguments to make in the next case that was set on the docket? And that was 21-2388. And that is the Messine Hercule case. I believe you've made your arguments, but I want to give you one more opportunity. You have any more arguments to make?
Judge, I'm satisfied with the arguments that were presented this morning.
Okay. And Mr. Middlemark, same offer. Any other arguments to make in the case that was set for the docket at 10 a.m.?
No, I have nothing further.
Okay.
I'll rely on my briefs.
All right. Thank you, counsel. We appreciate your arguments. You all have a great day.
Thank you, Judge Wallace. Thank you, Judge Sasso. And thank you, Judge Harris.
Bye-bye.